on in Florida. Please explain, before we get into what the attorney's behavior has been like, which has been, again, sort of stunning, in the most simple way possible, help my audience understand how the stand your ground law applies and how it works in this case, because I'm not sure who was standing their ground in this particular case.
Well, there's two significant aspects to stand your ground. One is the literal stand your ground provision, which allows somebody to stand their ground and use force as opposed to the requirement to retreat, which was the old law. But the more important aspect for this case is the immunity provision. And that basically says that if a defendant can prove by a preponderance of the evidence to the court that he acted in self-defense, then he is immune from prosecution. So the case could not go forward. So it really sort of puts another step in the process. Even if a defendant is not found to get the immunity, in other words, can't prove it by a preponderance of the evidence, he can still come in front of the jury in the trial and claim self-defense, at which point the state has to disprove it beyond a reasonable doubt. So it's a multi-step process.
So, Mark, it seems almost an impossible task, though, to get that, right?
Well, Jeff raises the point that jumps out at me when you look at this statute. Everybody's talking about trial, trial, trial. We're not even close to that, because this idea first of getting over the hurdle of the immunity, the judge could rule at some point.
Like tomorrow when he goes in for his bond.
Well, you do, I assume, and Jeff could correct me if I'm wrong, that it's in connection with some kind of a probable cause proceeding that they do this, that the judge then can make a decision. If the judge grants the immunity, case over, done.
So he has to, let me make sure we get this right. So if he's able to convince a judge that he was defending himself, he believed he was in harm's way,
and he's using the force necessary. You can't use excessive. And correct me if I'm wrong, Jeff. He has to use the correct amount of force. And you don't have to prove that as a defendant beyond a reasonable doubt, according to the statute. Just a preponderance, which is, you know, basically the scales of justice just a little bit more. A judge could rule you're immune, and that's it. Case over.
So what you're saying is you're going to get your bar in Florida and spend a lot of your time down there, because it seems like things are much easier for a defense attorney down there, no?
I don't know about that, but I'll tell you right now, it sure makes L.A. look like a tame place.
And that's right, Jeff? That's what he's saying is the correct interpretation? Yeah, well, I want to talk more.
The hearing...
Go ahead.
No, the hearing that would take place, it wouldn't take place real quickly. The Arthur hearing I heard you speaking about before is really a hearing about bond and whether proof is evident, presumption great, whether he can be held on no bond. This self-defense hearing would be much later in the process after discovery has been completed.
Okay.
Much